Okay, my Wi-Fi did. Jerome, can you hear me?
I can.
All right, good morning, everyone. This is Judge Lemaire calling the David Wayne Redkey matter, PB 2009-002-224. We're set today for an initial hearing on a petition for partial release of funds filed by Mr. DeLauro. If I could have announcements. Mr. Mazza, I'm going to start with you.
Yes, good morning, Your Honor. Danny Mazza. I am counsel for David Redkey, who is present.
All right, thank you. Mr. DeLauro, I see you're online with us.
I'm off camera. I'm in a hotel room with poor internet. So I'm the attorney for.
All right, thank you. And good morning, Mr. Theut.
Your Honor, Mark Theut, guardian ad litem for David Redkey.
All right, thank you. So who's online with the 7? Thank you so much, Ms.
Morning, Your Honor. Jerome Melville on behalf of the former conservator.
All right, thank you. And who is Tony?
Oh, yeah, this is Tony. I'm here for another case, I do believe.
All right, Tony, which case are you here for?
I do believe the estate of Charles Williams. My lawyer is Virginia Rigid, I do believe.
All right, so
I
you're
don't know if I'm supposed to be here or the next one.
you're on the next one, sir. That doesn't start for another 15 minutes, okay?
Yeah, so
If you can either
put me in a waiting room?
you can, well, I can't put you in a waiting room, but you can either disconnect and call back or just mute yourself, and we'll start your hearing as soon as we're ready.
All right, I'm mute. Thank you.
All right, thank you. Mr. Redkey?
David, just say your name.
Just want to make sure we're mic'd up.
Sorry.
All right, thank you, Mr. Redkey. And then who is Tassin, paralegal?
Yes, I'm from Sun and Wealth Protection Law.
All right, thank you so much. I'm just trying to make sure we have everyone mic'd up properly. Mr. DeLauro, it's your petition. How would you like to proceed today?
Well, regarding the release of restricted conservatorship assets, I guess let's see if anyone disapproves or objects to it.
Okay. Are there any objections to the petition?
Your Honor, I asked my client this morning, and he told me he has no objection to Agatha's petition.
Okay. Mr. Elwell, I don't know if you're going to take a position as former conservator. I presume not.
We are not taking a position on this, Your Honor.
All right, thank you. And Mr. Theut.
Well, Your Honor, the petition doesn't set forth exactly how the proposed funds are going to be used. Mr. Redkey may not have any objection to it, but it would be nice to get a little testimony, or Mr. DeLauro could avow to the court in round numbers how he intends to spend this money, and whatever he's kind of got it situated or request that they can take money periodically as they need it. But I want to make sure that whatever orders entered by the court, that if money's withdrawn, that the balance remains restricted.
Okay. Mr. DeLauro?
Yeah. Yes, Your Honor. We could put Agatha Redkey under and get her to explain how she would plan to use the money. And one other thing I'd like to explain: there was some time ago, I believe the parties actually agreed on another stipulation whereby Stephanie McCullum would be paid a certain amount, and the Theut law firm would be paid. And apparently that never got filed. And I'm actually hunting through my emails right now and trying to figure out the status of that. But that would be actually relevant to how the funds are going to be used. But I guess for right now, let's get Ms. Redkey under oath and have her explain how she would be planning to use the money.
All right, certainly. Ms. Redkey, if you don't mind raising your right, we're going to get you sworn in, okay?
Okay.
You do solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right, Mr. Delary, you want to start with the questions?
Sure, Ms. Redkey. We worked together and created an amended petition to release restricted conservatorship estate funds. And do you remember us talking about that?
Yes.
And can you explain why it is that we're looking for $200,000 to be available currently for paying ongoing expenses and so on?
Well, the original bond was for 150, and according to our conversation, you said that the Theut firm recommended a $200,000 for the year. It's requested, but it's originally 150.
Oh, Mark Theut recommended that.
Mr. Redkey, please don't interrupt Ms. Redkey's testimony.
Through the restricted account at a later time. So these are for fees going forward. That if I had any issues to the ongoing fees going forward, that I would object to them during accounting.
And over the last couple of months, we also were working together with Mark Theut and Danny Mazza on behalf of your husband regarding a stipulation to pay some of the expenses. Do you recall that?
Yes.
And that was going to be an agreement to pay outright $40,866 approximately to the Mark Theut or his law firm, $39,274 to Danny Mazza's law firm, and then $20,000 to fiduciary management specialists. Do you recall that stipulation?
I do. Was that, but I was under the impression that that was a separate filing and not part of this one. Was that in?
Well, that's correct. And apparently it never got filed. But would the plan be to use the funds that would be released towards paying those outstanding debts, namely $40,866.10 to Mark Theut, $39,274.60 to Daniel Mazza, and $20,000 to fiduciary management specialists? That was a question. Is the plan to use the $200,000 to pay those expenses?
That wasn't the original plan, but it can be. That would just mean that that we would have to go back sooner rather than later to the court to request funds for David's expenses.
Okay.
In less than a year.
Okay, understood. So you're still wanting us to file this stipulation requesting the release of those monies to pay those debts, and then the $200,000. Can you explain to the court what that would be used for?
Yeah, like I said, for David's disbursements and attorney fees going forward. Because when I became conservator in it's been about a year and a half now, and $150,000 went by already. So, and that was just for, my lawyers and David's expenses, because I have been withholding payment because I haven't received responses on questions for invoices. So that money will go quickly.
Okay. I have no further questions.
All right. Mr. Theut, Mr. Mazza, any questions?
I have a question.
Yeah, sure.
Was that you, Mr.
I have
Theut?
one question.
Sure. Go ahead, Mr. Theut.
Thank you, Your Honor. Mrs. Redkey, what do you estimate your average monthly expenses for you and David are?
David received the monthly disbursement of $5,000 per the court order, and the household expenses that are paid by the conservatorship are, let me pull that up.
Mrs. Redkey, just estimate it. I don't need an exact dollar. Can you just give us approximate amount?
Yeah. $2,300 for, so about $7,300 monthly for David's disbursement.
Your Honor, no further questions.
Thank you. Mr. Mazza?
I don't particularly have a question, although it sounded like my client had a question he wanted me to ask. Or he wanted to propose.
Yeah.
Could he pose? Your Honor, is it okay if David asks his question? I realize he has to keep it brief if he does.
Well, he can tell us what the question is, and then you can tell me whether you really want that to be asked of our interpreter.
Okay. Thank you, Your Honor.
Thank you.
David,
Because she has been advised and told, and we've been constantly told to pay up front, pay first, pay Theut first. Don't challenge those fees, because when Stephanie McCollum was conservator, she refused payments constantly. She actually didn't. Didn't pay all of my IRS. That's why I filed a complaint with the fiduciary board with her for like I got an IRS thing because she underpaid that. And she constantly stopped. She refused payments, refused to do things. And then the same thing happening now is saying, no, just give us, we'll give you guys, we'll use you as a blank check. We'll just put in money and you just pay us, and then you can challenge later, which does not seem like responsible, because that's going to incur additional fees, because if the requested amount is not legally binding or it's improper at the beginning, paying it first would just add additional costs. And what we're having now, specifically with McCollum, is, well, no, you need to drop those complaints now.
David, I'll email you.
You just have to consider that money lost, and
David,
and it's not showing it to be fiduciary. I mean, not to be responsible or prudent.
David, I'll email you the history of that Rule 33 process, because it used to be that you'd have to file the Rule 33 to get paid. You'd have a hearing, and they changed it like 15 years ago, and it actually does save money, is more efficient. I'll email you about that. But I understand what you're asking, which is, are we supposed to be paying on an ongoing basis each month and then getting it approved at the end, or are we supposed to get approvals and then pay? And I'll email you about that, because there's a specific court rule about it pertaining to the probate rules. I don't think that's a question Agatha can even answer, so I'm not going to ask it.
No, I know it would be for the court to answer.
Right. And I don't think Judge Lemay is going to be answering.
Well, right now, the questions are for your conservator. So that's who we're questioning currently.
Okay.
All right. So it looks like, doing raw numbers based on what Ms. Redkey testified, it looks like we've got, assuming we can get the litigation to stop, about 10 years left of,
actually 6 years,
conservatorship assets, also depending on stock market gains, how these matters are invested, et cetera, et cetera. So based on the testimony, Mr. Theut, do you have any objection?
I don't, Your Honor.
All right. And Mr. Mazza?
No, Your Honor.
All right. So I will grant Ms. Redkey's petition. I don't have a proposed form of order, Mr. DeLaury. If you could circulate one amongst counsel and submit it to us, we'll get that signed as soon as it's available.
Understood.
Okay. And I understand
Thank you.
you may be on the road, so the court understands that. I know Mr. Mazza is also traveling today, so I do appreciate everyone calling in. But as soon as we get that, we'll get that signed and uploaded so that your client can have access to those funds.
Okay, thank you.
All right. Sorry, Mr. Elwell.
Thank you, Your Honor. You heard briefly from Mr. DeLowry. There is a stipulation regarding the approval of Ms. McCollum's first annual account and second and final annual account. That stipulation was circulated and signed by my client, signed by Agatha Redkey as conservator, and signed by myself on behalf of Stephanie McCollum. As of the 24th of June, that matter was then returned to Mr. DeLowry for his execution and Mark Theut's execution and the filing with the court. To my knowledge, that document has not been filed with the court, and I need to understand whether or not it's going to get filed with the court so that we can end the litigation with Ms. McCollum, because I stayed all of the depositions and discovery that we were planning to do before the evidentiary hearing because of that stipulation. And I just want to know whether we're filing it, whether we're done, or whether we're going to have to proceed.
Well, is this the stipulation? Is this the stipulation regarding approval of Stephanie McCollum's first annual account, second and final account, filed the 24th of June that Mr. Mazza and his client objected to?
It was, there was a stipulation filed. Okay. Mr. Mazza and his client objected to it. We were told later by Mr. Mazza that Mr. Redkey agrees now with the stipulation, but we haven't gotten anything on file so that we can end the litigation.
I actually didn't agree with it. I didn't
actually say I agree. I said yeah.
You are no longer contesting for legal purposes.
Correct.
Okay.
We are not contesting.
All right. So I have it on the record that Mr. Mazza is no longer contesting.
But Your Honor, would it be appropriate if we provide you with a form of order granting the stipulation?
Yes.
And ordering the payment of the funds under that stipulation, as well as a release of my client and termination of her conservatorship?
Yes, I think based on the stipulation previously filed and Mr. Mazza's representation and the concurrence of his client, today I can, yes, I can sign a proposed form of order in accordance with that stipulation.
We'll have that filed for you by the close of business today.
All right, and my understanding is that will then also allow us to vacate the hearing set for next week.
Correct, Your Honor.
All right, fantastic. I look forward to signing it.
Thank you for your time.
All right, thank you. I appreciate it.
Thank you, Your Honor.
Take care.
More issue I'd like to address just for a second, if you've got time.
Sure.
Just so we'll make it quick. You know, Mr. Redkey seems to be a little confused about a prior order of this court that he's not to post anything from court hearings online. And I've seen something last 2 weeks where that's been put online. He happened to arrive down at my office. He went and took a picture of the front of the office. He's posted that online. I've also been advised he has AI glasses. He's recording stuff on a regular basis. Your Honor, I think I was about ready to file a motion for sanctions because he knows he's not permitted to do this stuff, but he needs to immediately remove everything online and stop posting things.
All right. So, Mr. Redkey, there are rules about recording court proceedings without permission. when the media wishes to record, they have to ask for permission, and that does include note takers, the use of any sort of AI glasses, meta glasses, those sorts of things. That is against rules and statute. We do have, however, you are allowed to post the formal FTR recordings that you can request from the court, because those are the official transcripts of court proceedings.
Yeah, that's what I posted.
Those are open to you. And then again, we ask you to be mindful of everyone's need for security and remove any postings that either are photographs not taken with permission and any recordings that were inappropriately posted. So I need you to remove those, okay?
Okay. Yeah. The ones recording, like when I was in front of Theut's office, that's actually legally allowable, because that's, from my perspective, and that's, we are a single party consent state in Arizona. So I consented to record that. So from my perspective.
Well, do me a favor, run it by your counsel just to make sure that you're not on the wrong side of that.
Yeah. Yeah, run it.
Okay.
Okay.
I understand, Your Honor.
All right, because I will entertain any protective motions if needed.
Okay, I understand, Your Honor.
All right, with that, we are adjourned. Thank you, everyone.
You're good.
All right. Good morning, everyone.